So what I'm going to do is I'll open up just by explaining business rescue. Business rescue is dealt with in terms of our Companies Act, and it only deals, it only relates to companies and closed corporations. So when it comes to partnerships, when it comes to sole proprietorships, business rescue doesn't apply. But that does not mean that COBRA won't assist those businesses. We assist absolutely everybody. Business rescue is really a tool. It's the tool that's made use by COBRA because the moratorium comes into place. The moratorium prevents legal claims. But I see Peter Gordon's joined us. So I'm going to ask him just to take us through business rescue in general. Peter, in fact, before I do, let me introduce my panelists. We have Peter Gordon is from Engaged Business Turnaround. Ian Flemming is also from Engaged Business Turnaround. Gary Barachowitz from Schindler's Attorneys, and Renee Klopper from IQ Business. Ian Flemming and Peter Gordon are business rescue practitioners, so they're involved. They're in the thick of it. And I see that Peter's hopped off, and I think Ian's possibly struggling. So, Ian, are you there? No, this seems
yes, Maurice, I'm here. Maurice, I'm here.
But no, I just can't see you. So, Ian, I was hoping you could just take us through business rescue, what you've been seeing, how things have been going in the market and through COBRA. We've had plenty of referrals. The insights on our website reveal that. But what's happening on the ground, and how's it been going?
Thanks, Maurice. It's certainly heating up out there. We, in the beginning when lockdown started, and when lockdown started, we were inundated with calls from companies who were immediately affected by the lockdown and so on. So it was a lot of restaurant groups and hospitality companies and so on. What we're seeing at the moment is, as time has progressed, as the economic impact has been felt, we are seeing larger companies now coming to us, the ones who had some cash reserves, and those cash reserves are gradually dwindling, sadly, and they're reaching the point now where they need. The creditors are also starting to push for payment. Landlords are under their own sort of kind of pressure from creditors, and it's getting to the stage now where sort of medium to large size companies are going into business rescue or needing to go into business rescue at quite a rate, requiring the protection that business rescue can offer, effectively to put a pause on everything, and to allow for the company and for the effects of COVID-19 or the immediate effects of COVID-19, hopefully to pass, companies to restructure themselves, to downsize, as the case may be, and then hopefully continue trading, often on a smaller scale than they were before.
Sure. So just to have the audience understand, in terms of the Companies Act, if a company is financially distressed, it's obliged to actually put it to a vote by the board of directors. A vote to place the business into business rescue, and if the board votes against business rescue, they need to send a notice to their creditors and their employees explaining why the vote went against business rescue. Now, what's meant by financially distressed in terms of the Act is really commercial insolvency as opposed to factual insolvency. So commercial insolvency is when you cannot pay your debts as and when they fall due. Factual insolvency is when your liabilities exceed your assets. And it relates to whether there's a reasonable likelihood that you'll not be able to meet your financial obligations in the ensuing 6 months. So if the board's formulated a view that there is that reasonable likelihood, then the board has to put it to a vote. And that's essentially what COBRA has done. Is COBRA has given companies a reason to not put companies into business rescue. So there's an irony, because a lot of people think, well, COBRA is about business rescue. No, COBRA is about turnaround. So if a company is financially distressed and you have to put it to the vote, what you say is, we're not putting the company into business rescue because we're putting it into the COBRA ecosystem. And then what happens is you'll have the likes of Ian Flemming, a senior business rescue practitioner, or Peter Gordon, who will assist in liaising, mediating arrangements with your creditors, dealing with employees, and really trying to help the business in any way which possible, but without the actual rescue taking place. The rescue will only come down like a guillotine in the event of a creditor being unreasonable. And the idea is that we get your creditors into the ecosystem, and we go all the way up to a banking level. But now, Ian, I mentioned compromise earlier. Just still want to take the audience through an alternative, a statutory alternative to business rescue. Ian? You're on mute. I think we've lost Ian. So the statutory alternative is Section 155 of the Companies Act. Yeah, and I see you there now.
Sorry, Maurice. Apologies for that. Yes.
Load shedding and all sorts of things. So my apologies to the audience. But Section 155, over to you.
Certainly, thank you. Section 155 compromise is allowed for by the Companies Act as an alternative, as a potential alternative to business rescue. Interestingly enough, a Section 155 compromise can be effected when in normal trading circumstances, or even when in liquidation, but it cannot be effected whilst the company is in business rescue. Section 155 compromise makes provision for a turnaround practitioner to negotiate a compromise with each class of creditor. So the classes of creditors as defined by the Insolvency Act, being secured creditors, preferent creditors, and unsecured creditors, each need to agree to the compromise that is proposed by the turnaround practitioner. So for a specific company, the turnaround practitioner will, for example, he'll put together a plan that sees the company returning to solvent trading conditions, given the fact that the secured creditors are taking, for example, a 10% haircut or compromise, preferent creditors are taking a 40% compromise, and concurrent creditors or unsecured creditors are taking an 80% compromise. That plan sees the company returning to a solvent going concern. The turnaround practitioner calls everybody together for a meeting, and it's required that 75% by value of each class of creditor who elect to vote pass the plan in order for it to be approved. Once it is approved by each class of creditor, now you can imagine there's a big negotiation process that takes place, and often it is only one class of creditor that is affected. If it's only one class of creditor that's affected, then only that class of creditor needs to approve the compromise. Once it is approved by the creditors, the turnaround practitioner then takes the plan to court, has it made an order of court, and thereafter the creditors are compromised to the extent envisaged by the plan, and the plan can be rolled out. One thing I forgot, Maurice. One of the let's say downsides, or one of the potential problems with the Section 155 compromise, is that during the process of putting the plan together, the company does not have the legal protection that a company has under business rescue. So from the commencement of business rescue, company has legal protection, or as me and my colleague Peter Gordon likes to call it, a steel jacket, which protects the company from any legal action whatsoever. Protects it from the possibility of liquidation, it protects it from repossession of assets and that sort of thing. And during the process of a Section 155 compromise, of putting it together prior to being made an order of court, the company does not have the same legal protection afforded to it by business rescue. Thanks, Maurice.
Sure. If you don't need the steel jacket, is there an advantage one way or another? Which one do you pick?
Sorry, Maurice, what is that? If you don't need it?
If you don't need the steel jacket on a 155, which one would you pick?
If you don't need it, then a Section 155 compromise can be done a lot quicker and a lot more cheaply. It's really about if you've got creditors who are willing to negotiate, creditors who are understand the fact that a compromise is required in order for the company to carry on trading. And if that is the biggest problem, if the company's debt burden and its potential to service that debt burden is the biggest problem, and without that debt burden, it would be able to carry on without any other substantial intervention from a turnaround practitioner, then Section 155 compromise is the way to go. Sometimes the intervention of the turnaround practitioner is really required in order to restructure operations and restructure finances and so on, as opposed to just restructuring creditors. That can be built into a Section 155 compromise. It can be built in whereby after the compromise is made an order of court, then the practitioner can carry on in being involved in the company and assisting it to effectively turn around. But the business rescue process gives the practitioner ultimate control over the board, so he has a lot more kind of say in implementing the plan.
Yeah, interesting. So another important feature of business rescue is we have the moratorium with the steel jacket, but there's also the question of contracts and what comes with it. The take home that we often raise and we say to the audience, please make note of this, is if you're going to not use COBRA and you're going to put your company into business, please make sure that the business rescue practitioner sends notices out in terms of the Companies Act suspending those contracts. Because if the business rescue practitioner doesn't do that, those contracts remain in force and can be cancelled, and then legal action can be taken pursuant to the cancelled contract. So to give you an advantage, a lease agreement or leases agreement that you've entered into for your business, if the business rescue practitioner does not suspend that lease, that then means that the landlord is in a position to place you in breach and then cancel the lease. And if the lease is cancelled, and eviction is appropriate. In fact, the first case dealing with that was Gary Barachowitz, who's a panelist today. His father's a judge who handed down judgment saying yes, an eviction is appropriate because the business rescue practitioner had an election to either continue with the contract or suspend the contract. And if the business rescue practitioner does not suspend the contract, well, you're going to live by that election. So very, very important. Just on that score, yeah, and how many notices have you sent out thus far with COBRA clients? Has it been necessary? How have you found it? You're on mute, sorry, Jan.
Maurice, we often take the view that unless there's a good reason not to, we suspend leases and we suspend contracts, and then we negotiate from there. Most creditors, most landlords understand that to be our standard practice, and they're quite comfortable with it. That doesn't really come as a surprise when we suspend those contracts. But yes, so the moment a company goes into business rescue, before breach notices and so on can be received, we tend to suspend those contracts. We have sent out, I mean, it's an extensive, it really is an extensive list of contracts that we have suspended, and we use that as a starting point for negotiating with landlords and with lessors towards contracts that are favourable to the company whilst in business rescue, whilst in financial distress.
And would you say that the counterparties to the contracts have been reasonable?
Yeah, the counterparties have been very reasonable. As I said, that everybody seems to understand that we're in a completely different environment. We're in an environment where trade volumes are substantially lower. In best case, in a lot of our clients' best case, trade volumes are 50% lower, than they were before. Obviously, in some cases, companies haven't been able to trade at all, and we find ourselves 100% lower, due to the company not having any turnover whatsoever. So it doesn't really come as a surprise to landlords, when we suspend those contracts. And then every landlord at the moment is sitting with a ton of tenants who are basically trying to negotiate with them, trying to negotiate a better deal. And the ones that are in business rescue tend to get more attention from the landlords. It's actually easier to negotiate with them whilst we are in business rescue. So business rescue has certainly been a valuable tool in order to assist us in renegotiating leases and so forth.
But there's always the issue, and companies are reluctant to put their businesses, their companies into business rescue, the stigma. What's your view on that? Can you comment on that?
Yeah, certainly. Look, in the COVID environment, there is no stigma attached to business rescue whatsoever. It's really, it's changed. Everybody understands. We did a webinar yesterday for the hospitality industry, and I mean, every single one of those attendees has got a company that is in financial distress. Literally, 80-90% of the economy is currently in financial distress, if not more. So, the Companies Act, the law says that if you're in financial distress, you need to consider business rescue. And there's certainly, in this environment, there's no stigma whatsoever to going into business rescue. So yeah. Sorry, Karen.
Yeah, no. I was gonna move on to you say hospitality business and the revenues are down. They obviously need finance. So, what are their options there?
Well, the options, look, there are.
Peter's also seems to be on mute. So you take it.
Okay, sure. So the options are, okay, so if you as a shareholder or a creditor, you're going to put money into a company, it's much better to do so under business rescue as opposed to doing it prior to business rescue. The reason for that is once it goes into business rescue, your claim is preferent. In other words, should the company end up, on the repayment of those claims, your claim ranks as post-commencement finance, and you will be paid out first. If you put money in prior to going into business rescue, then you rank as concurrent alongside all the other creditors. So your claim is not nearly as secured as if you were to put loans, if you were to loan the company money after it's gone into business rescue. Very important, when you are loaning money to a company that's in business rescue, try to secure your loan through some sort of asset that is in the company. Should the company then subsequently liquidate, then you're sitting with a secured claim as opposed to a concurrent claim, and it's secured over an asset, which puts you top of what we call the waterfall when it comes to repayment of creditors. There are people, companies or lenders that do provide post-commencement finance. It's not a very mature market in this country. In developed countries like the States, it's a lot easier to get funding for companies that are in distress. Obviously, they come at quite a cost, a borrowing cost. In this country, typically your post-commencement finance lenders are creditors who already have a vested interest in the company. In other words, it's normally a shareholder who's putting more money in, or in the bigger cases, especially, it's the banks who the business rescue practitioners will turn to for post-commencement finance. That being the banks that are already exposed to that company. It's very unlikely that you'll be able to get another bank that's not exposed to the company to put money into it.
Yeah, and I think an important take-home there is that we're finding where post-commencement finance should be utilized, and that's where you have staff and you want to fund their salaries, as an example. What we've seen on business owners pulling out the cash out of their pockets, paying the staff, being really benevolent, which is good in these times, but not putting the business into business rescue to take advantage of the PCF provisions. So the post-commencement finance, if you were to, for instance, if you were called upon to pay in terms of a suretyship, now you have the money, the business doesn't have the money. What is best is that you don't pay the bank directly in terms of surety, but rather put the business into rescue, then lend the business the money as PCF, and then have the business or the company pay in discharge of the liability. So that's hell of important. And on the question of employees, I think it's also important that we did deal with that in this discussion. Employees, unlike the contracts that you can suspend, all other contracts such as lease agreements and other agreements, you cannot suspend an employment agreement. the law remains in place. The Labour Relations Act remains in place. Nothing changes. In fact, I would say that employees are afforded more rights in terms of that because of the participation and the fact that they've got to receive notices and they're involved in the process. So they're closer to management, they're closer to business rescue practitioners. And that often confuses people because of what I do. I don't have money to pay the employees. There are certain times where you don't have to pay the employees when they cannot perform, and a lot's been said around that, where if it's just impossible for them to perform because of a lockdown, doesn't want to have to pay, and there have been conflicting judgments in the High Court and the Labour Court. And the High Court, they went and said that you do have to pay in that situation, and in the Labour Court, which is regarded as the correct judgment, says that you don't have to pay. But that is a very, very peculiar situation. It only happened when the businesses were closed, such as restaurants, where it was completely impossible to perform. Now, outside of that scenario, you still have to pay your employees, but what if you don't have sufficient money? And that's where Ian and Peter come in. They will meet with the employees and they will not try and get them to agree to a reduction in salary, but rather to a fixed reduction in salary, but rather a variable reduction in salary. So what they'll do is ask their employees to accept a lower salary for a particular month, but only in the event of there not being sufficient cash to pay salaries. And then that can, of course, be made up later. But if you're going to enter into an arrangement like that, you have to consult with the employees. Section 189 of the Labour Relations Act provides for the provisions that you have to follow in either varying an employment agreement or if you're going to dismiss based on operational requirements. Now, often it's asked, why on earth would you go down the dismissal based on operational requirements route, but I don't want to dismiss, but I just want to vary the salary. And the reason you have to is you always have to afford the employee the right to accept a severance package in lieu of agreeing to a reduction, which also, again, is problematic because what if you don't have the money? What if the employee's been there for over 20 years? And there again, that's where Peter and Ian would come in and they'd actually try and negotiate in those circumstances a payment plan of some sort to go into it. So I'm going to ask Ian once again. Ian, you just tell us how on the ground it works with employees.
Certainly, Maurice. Employees have received a lot of attention lately as a result of the SAA saga, and I can touch on that briefly as well. But basically, once a company goes into business rescue, they've got 5 days in which to appoint a business rescue practitioner, 5 business days. Once the business rescue practitioner has been appointed, it's then incumbent upon the business rescue practitioner to call what we call a Section 147 meeting and a 148 meeting. Section 147 meeting is the first meeting of creditors, and the Section 148 meeting is the first meeting of employees' representatives or employees. They both have to happen within 10 business days of the business rescue practitioner being appointed. So at that meeting, and specifically the Section 148 meeting, which deals with employees, the business rescue practitioner has to express to the employees or their representatives whether or not he believes there's a reasonable prospect of rescuing the company. The employees obviously want to know whether they're going to have jobs at the end of the day. The business rescue practitioner can then invite the formation of an employees committee as well, with whom he will deal with. So that in practice, that doesn't really happen very often because the committee doesn't really have any legal standing. So the business rescue practitioner will basically deal directly with the employees' representatives. If at any stage during the business rescue process, the business rescue practitioner believes that the company cannot be rescued or cannot give creditors a better return than in liquidation, then he is legally obliged to liquidate the company. So that at all stages of the business rescue practitioner has to be satisfied that there is a reasonable prospect of rescuing the company, and he needs to be able to communicate that to affected persons, which includes employees. what's very interesting is in the SAA saga, the business rescue practitioners commenced the retrenchment process, the Section 189 process, after business rescue had commenced. The unions then went to the Labour Court, and the Labour Court found that business rescue process cannot commence until a business rescue plan has been published and approved. This went to an appeal, and the Labour Appeals Court upheld that ruling. So this makes it very interesting now, because we're actually busy with a case at the moment where the retrenchment process, the Section 189 process, had commenced prior to business rescue starting. And the question now remains, can it continue, given the fact that the process had started before business rescue had started? And the precedent set by the SAA case is that once a draft business rescue plan has been published, the consultations in respect to the 189 process can then continue. However, the retrenchments can only be made effective by the approved business rescue plan. So the final approved business rescue plan has to include the retrenchment process as envisaged by the business rescue practitioner. And only when that plan is approved by the meeting of creditors can the retrenchments be immediately effective. In other words, the approval of the plan is what would make the retrenchments immediately effective. However, based on a draft business rescue plan published during business rescue, but prior to the approval of the final plan, based on that process, the business rescue practitioner can start or commence or continue the Section 189 process. I hope that answers your question, Maurice.
It does. I'm just trying to understand practically how that would work, because Section 189 says that you have to consult with employees the moment dismissal based on operational requirements. So what would happen is you have an obligation to consult the moment you contemplate retrenchments, which is the moment you're in financial distress. You have that obligation, so you do consult. Then a business rescue practitioner gets appointed. The business rescue practitioner has to put together a plan. Now, practically, what if there's no money to pay salaries? How does, you've got this plan, and so you have meetings with creditors. How practically could you ever, how would it work? And particularly when it comes to big companies, yeah?
Maurice, if there is no money, there's no money. The retrenchment process has to happen in order to downsize the company. And at the end of the day, if there's no money in the company, which is a reality in a lot of cases that we're dealing with and have dealt with in the past, and if there's no money to pay the retrenchment packages, then there is none. Then it's a case of the business rescue plan should then propose how the company will realize money, will generate money, be it through the sale of assets, be it through the sale of divisions, or be it through operations. The proceeds from those cash generating efforts can then be applied to paying the employees in terms of the retrenchment. But yes, we've seen it quite often. Companies have to effect retrenchments, but simply do not have the money to do so. What is very important is that during the entire process of consultation with staff, consultation with employees, representatives, and so on, it is communicated to them that the company is unlikely to have money, or the company will only have X amount of money to pay either their severance pay or their notice. Remember, a month's notice is also required in terms of the Act. So it often does happen that there is no money to pay it, but it's very important that it be communicated so that the employees, in assessing the options that are available to them, can bear that in mind when deciding on the options that are available to them.
You'll have seen the Mazepoli Plucker judgment. Now, that was a High Court judgment handed down about a month. And in that judgment, that's where the court said a liability did arise even under a lockdown. You couldn't make it to work. that judgment being not followed in the Labour Court. And in that judgment, what's quite key there was it was the employees that put the companies into business rescue. So they were the ones to apply. It wasn't the directors who decided to. And it was an opposed motion, and the employees came right from the High Court ordered that the business going into business rescue and practitioners are now in there investigating and see how they can have the employees paid. But I mean, in the case of a restaurant, isn't a liquidation so high risk that the employees ought to, they ought to realize that they won't get as much in the liquidation, and it would be better to work with you guys. Wouldn't you say, Ian? Sorry, I'm mute again.
Sorry, I lost part of the question. Perhaps Peter could answer that. I was just changing from my computer to my phone.
Maurice, sorry, the sound was quite, I couldn't hear the question either. Something about, I mean, I think, correct me if I'm wrong, interrupt me. Should staff rather go for a liquidation, a rescue than a liquidation?
What I'm saying is, when it comes to employees, the alternative to a business rescue is a liquidation. Now, if the employees are to be paid their salaries prior to the plan being published, okay, a liquidation is virtually inevitable, particularly if it's going to take time with the plan. But shouldn't the employees be informed that on a liquidation, they'd probably be worse off, because then there's absolutely no likelihood of them continuing in their jobs?
Maurice, yes, it's a valid concern, and the unintended consequences, which I think is a positive, is that practitioners are now working a lot harder to make sure that their plans are approved a lot quicker. You know, in the past, I think what practitioners often tended to do was delay the approval of the plan, trying to get us sort of all the T's crossed and the I's dotted. And what's happening now is we're getting plans coming out. EdCon's a good example of this. The practitioners got it out in record time, but there's a lot of question marks over the plan of how it's going to unwind. So I think what's happening now is practitioners are not saying, well, let's get everything tied up and neat, so that when we publish the plan, it's a fait accompli of how it's going to roll out. Because of this very fact, because if you're going to go through redundancy, as Ian rightly says, the draft plan needs to be published, and that just puts some pressure on you. But bearing in mind, you've got a very tight timeline in order to publish the plan if you comply with the Act and don't ask for an extension. And in that case, it makes sense to get it out as quickly as possible.
Peter, whilst I've got you on, we're talking SAA quite a bit. In SAA, we saw the Dudunieni judgment, which was declared delinquent by the High Court. IOTA brought the application together, I think, with certain employees. But I was actually involved in litigation back then, and it was quite unbelievable what was happening. What we saw was a deal, the Emirates deal, being torpedoed for whatever purpose, but it was being torpedoed, and as far as we're concerned, we concluded that there was gross malfeasance. Peter, whilst I've got you on, what do you do? What are the duties of a practitioner when it comes to malfeasance? And how do directors react when you come on board and there are concerns? Let's say they've been drifting the books a bit.
Maurice, look, one of the important things that I often say to people is just let's underline the word business rescue, which is what you're trying to do. Now you get the extremes. Ian and I will always cooperate with the directors. However, the practitioner is in supervisory control of the board. So you can decide to use directors or not. It's a practitioner's choice. You can't remove a director from the board unless you go to court to do so. But you can say, let's say, for example, your finance director is not up to speed. You can pull in additional resources to perform the finance function and basically sideline the director from the FD position. But obviously not ideal. Where you've got fraud, malfeasance, it becomes extremely difficult. However, if the practitioner, remember, the practitioner can authorize any legal action in terms of the rescue, so you can undertake legal action against the director for wrongdoing, report the director as you obligated to do. Remember, in terms of Chapter 6, if the practitioner finds that the directors or management have been doing something that is untoward, illegal, he or she has a responsibility to report it to the authorities. Bizarrely, the Act doesn't say who the authority is, but if it's a financial services company, surely you'd report it to the FSCA. If it's just theft, you'd report it to SAP. And the problem with that, of course, it's now in the government domain, and whether anything gets done about it is debatable. However, that doesn't prevent the practitioner taking a civil action against the director if he's trying to recover, and that's the important point. If you're going to take legal action against anybody in a rescue, same as if you're going to sue one of your debtors for payment, just make sure that they've got the ability to pay before you start spending money on legal fees, because very often the mere fact that you're in rescue means you don't have access to huge amounts of cash. But the directors, our approach is always to work with the directors unless we find something to the contrary. And to the contrary would be, criminal acts. The issue of, and we quite often have it in the small to medium sector, where a director is anxious because maybe SARS they haven't been totally transparent with SARS. Our approach to that is we calculate what should have been disclosed to SARS. We approach SARS, we give them an amended return. We negotiate with them. Remember, SARS will also be compromised in the rescue plan if a compromise is called for. And generally, we find SARS will work with us. SARS are not there for the aim of putting companies into liquidation. That's under normal conditions. Certainly under COVID, that's become even more obvious that SARS are not going to be leaping to the law to liquidate a company if they haven't been paid tax. They'd rather negotiate with the company, and we're in a strong position to do that. But the bottom line is cooperate with the directors unless we find otherwise.
And a practitioner, I think it's important also to mention that you also have rights to remove a practitioner if there's been any malfeasance or failure to perform his or her duties. And on that score, I've actually dealing with the matter now. It's not a COBRA related matter. We're acting for a client who is a stakeholder. And the business rescue practitioners are up to no good. They're giving notices of meetings, 45 minutes notice, then trying to get stuff across. And now we have to look at a removal. And in that context, we have to persuade a court that a removal is justified, which requires a high court application, which is costly because chances are that application will be opposed by the business rescue practitioners. They don't want their reputation tarnished, and obviously they want to hang on to the work that they've got. So those are invariably always opposed. Are you aware of any, Peter?
Maurice, I'm certainly aware of some where there's been applications to remove, and there's been some ongoing debates because obviously the other person that becomes involved here is Sub-C, because essentially they are the we report into Sub-C as officers of the court. It becomes very difficult. I'm certainly aware of one where the practitioner was, I think, even challenged himself personally with a personal bankruptcy claim. So they are, and it's a very valid point here. One's got to be very cautious, extremely cautious. And that, this is not a selling point. This is just, if you're thinking of going into business rescue, please speak to your bank manager, speak to your lawyer, speak to your accountant, because like with everything, it's the same with all professionals. The banks have started keeping their own database of which practitioners they're prepared to work with. The lawyers will know from past cases who the practitioners are that need to be avoided. So do some research in that. And remember these two issues for the removal of practitioner. There's the illegal act, so acting in bad faith, fraud, etc. Then there's just the incompetence. Doesn't have the skills And the skills might be, and especially relevant at the moment, the practitioner might be inundated with rescues, and he's taken them all on. And, one has to also ask that of the practitioner. How many rescues are you dealing with? And what support do you have in your office to cover those? And if he's man alone, I'm aware of a practitioner that was on his own, and he took on 95 rescues. A lot of them were small, but still, it's inappropriate. Just complying with all the regulations in Chapter 6 alone is going to take a fair amount of your time. So if the practitioner is just incompetent because he doesn't report on time, or he doesn't get his reports out when he should, or the business rescue plan, when it's published, doesn't include all the information it should, then complaints to SIP-C can be made. Whether they go anywhere, I don't know. But as I say, there are some practitioners that people are actively avoiding at the moment.
Yeah. I want to move over just to touch on directors' duties. I just want to mention, and I'm not sure if it was mentioned earlier, but directors owe the same duties as they did prior to a rescue and more, because now they're subject to essentially a statutory kind of employment role where they now serve the business rescue practitioner. They have duties towards the business rescue practitioner. So that's one thing. Another thing I want to mention is qualifications of business rescue practitioner. Believe it or not, a business rescue practitioner requires a qualification, whereas a director and minister of parliament doesn't. So the qualifications are going to be accounting related, business experience, or legal, which is important. And on the legal side, we also at COBRA have mediators. So it's outside of the normal legal. Now, those mediators are actually employed by the business rescue practitioners. We're doing this on a pro bono basis for businesses that need it on a pro bono basis. And before I move on to the voting, I'm going to ask you, Peter, around the voting. I just want to make mention of a story, just a practical example of a business rescue. I'm sure the audience out there are like, this is quite intimidating. And it need not be, because I've dealt with a restaurant in Camps Bay, and what happened there was business took a downturn, and the lease was killing the business. As simple as that. The rental was too high. So what we did was we put the business into business rescue. This is outside of this environment. Outside of this, about 2 years ago. So there was no COVID. We put the business into business rescue. We sat down with the landlord, showed the landlord what the position was. The landlord immediately realized that this was not sustainable for the business and agreed to a reduction. Having agreed to the reduction, we pulled the business out of business rescue, and in a matter of weeks, the entire situation had been regularized. So whilst it's quite intimidating because of the expertise that's required, and you need a business rescue practitioner, from your perspective, you mustn't see it as intimidating. What you're doing is you're engaging with experts. They're coming in. They have a statutory weapon, which ought not make it intimidating. It means they're armed with something. So see it as, pulling consultants in to give you advice, lawyers, professional. We have 55 partners, in excess of 55 partners at COBRA, all of whom have pledged to provide pro bono advice to businesses. Cannot afford advice. So bear that in mind. What concerns us is that people regard the process as intimidating, and there's also the stigma. And Ian mentioned that there is no stigma at the moment. In fact, you are being responsible by approaching the likes of COBRA or considering business rescue. If you need further information on that score, we have it. Just email us, and we'll provide additional information on how the process works and how we can assist. But over to the voting. So now we have a plan. Just hypothetically, Peter, let's say the employees are owed $1 million and trade creditors 50,000, and we have a shareholders loan account to the tune of 20 million. So we'll make it huge. Shareholder loan account to 20 million, employees, 1 million, and 50,000 to trade creditors. How would the voting work on the plan?
Maurice, look, it's an interesting conundrum that we often face, is you have to be very clear on how you're going to get the plan through. So the principle of the business rescue plan, to get the plan adopted, is you need 75% to vote positively out of those voting. And that's also important. If somebody doesn't turn up to the meeting or doesn't send their proxy to the meeting, they can't claim afterwards, and it's very clearly laid out in the Act. They can't come back afterwards and say, I didn't vote for the plan, therefore I don't support it. So 75% of those voting in person or by proxy have got to say yes. But now importantly, so an example of you've got 100 Rand worth, and it's, remember, votes are by value. So you've got 100 Rand's worth of people voting. 75% of those that voted have got to say yes. However, 50%, so 50 Rands worth, have got to be independent. Independent broadly defined as it's not a interrelated company, it's not a fellow subsidiary loan, it's not a shareholder loan, it's not the family of a shareholder loan, a director loan, etc. So those have to be diluted essentially by a third in their ability to vote. So in the example you've given, Maurice, the 50,000 Rands worth of trade creditors have actually a huge sway here, because if they are going to oppose the vote, you don't have any independent creditors, staff and employees. Staff are not connected person. So if you owe the staff money, and remember you owe the staff money every day that they're working for you and you haven't paid them, so they are by default creditors, not least of all bonuses and leave pay, etc., that's still owing to them. So what you would need to do is make sure your staff are on board. If the creditors are on board, that's fine. Then what you do is you ask the shareholder not to exercise his vote, or at least only exercise that percentage, which means that you don't breach the independence rule that I gave earlier. So there would be a negotiation here. On the other hand, if you've got an acrimonious creditor, for this example that you've given, it would be far better for the shareholder to settle either full value or through the rescue prior to the plan being adopted, and approach the creditor, or the business rescue practitioner can approach the creditor and can buy the claim or settle it. And if you haven't got the cash, you can find a third party to buy the claim who's going to work with you, or you can ask the shareholder to put some money into the company. For example, money into the company post-rescue means it's preferred, so he's going to get paid before anybody else after the practitioners have been paid, and use that money to settle a creditor, and you've taken care of your problem child.
That covers it. But what happens if the plan fails? If you don't get votes, the necessary votes? I'm sure you've encountered this a few times.
Maurice, look, this is fraught. I've had situations where I've actually had a Mexican standoff where one party, two companies, and neither of them could come to the table. And if one voted for, the other was going to vote against. It was an absurd situation. So yes, one experiences this in real life. If the plan fails, there's quite a involved process. So at the meeting, the 151 meeting to approve the plan, anybody who's an affected person, staff, creditor, can propose an amendment to the plan. It could be a minor amendment, it could be a major amendment. The practitioner then at the meeting has to decide if he's comfortable that the proposed amendment is likely to make sure that the plan now goes through. So you might have a creditor saying, I'm controlling the process because I'm the majority voter, and you're offering, to pay the shareholders' loans in the same compromise as the creditors. Classic example. You're paying the creditors 40 cents in the rand and the shareholders 40 cents in the rand. But we're sitting here because of and I'm assuming the shareholders are the directors. We're sitting here because of the actions of the directors, and we don't think they should get as much as us. So you could have a quick sidebar to discuss with the directors whether they would be happy to, say, receive 35 cents in the rand, thereby upping the amount to pay to the creditors, and you could make that amendment. That amendment needs 51% to approve. If approved by 51% and, importantly, the practitioner, he then puts that into the plan for the voting. So then the amended plan gets voted on. If that vote fails, so you don't reach that 75%, there's a process to go through. The practitioner can firstly ask for a period, 14 days, to present an alternative plan. If the practitioner remains silent, and sometimes it's in your best interest to remain silent because you know what's coming, you get a creditor who stands up and can propose a plan, or an affected party can propose an alternative plan. If that happens, the practitioner then is obligated to go away and put that into the new plan and come back to a reconvened 151 meeting to agree this amended plan. If at that meeting it fails and the practitioner once again remains silent and can't come up with an alternative, then the practitioner is obligated to file for the failure of the plan at sub C, take the business out of rescue, and by default then has to apply for the liquidation, appoint liquidators to take over the sale of the assets. So ultimately it is liquidation. Obviously, in your employee example earlier, it's always 99% of the cases going to be worse off because the liquidator is forced to sell the assets. He has no right to trade the assets. And if you're thinking of in the current situation, if you've got a restaurant that you're going to liquidate, well, you know you're going to get nothing for it. There's nobody queuing to buy restaurant equipment. And that's a small business, but that analogy works right across the piece. So one has to try as hard, and some practitioners would just give up and say, well, put it into liquidation. But certainly in my experience and Ian's experience, we will try damn hard to make sure that we do improve the situation for the creditors.
Yeah, you're mentioning restaurants, and something we've come across now, the attitude adopted by insurance companies in relation to the business interruption insurance. And I think it's also important to mention there that business rescue can be about pursuing a claim, and only that. So the business rescue plan can be, we're going to pursue this claim. The creditors can vote saying, cool, go ahead, and then when the money is recovered from the insurance company, then the creditors get settled. So it can be that simple. And I'd imagine quite a few restaurants, to the extent that there is pressure, downward pressure by creditors, that'd be putting their companies into business rescue and pursuing those claims. Then I was hoping, Ian, if you're there, we're almost done, but if you just take us through the costs of business rescue. Before I hand over to you, I just want to mention to the audience that COBRA is pro bono. We have a means test to determine whether you qualify for the pro bono. The means test is on the website. And the idea there is if you cannot afford to pay for any of the professional services, in relation to the 55 partners that have pledged their services on a pro bono basis, if you cannot pay, if paying would mean that a business rescue would not be successful, then all the fees are waived. So fees will not come between a successful business rescue and a potential liquidation. There won't be a liquidation. And again, before I hand over to you, I just want to mention on liquidations. If you enter COBRA and we do not succeed in rescuing your business, we will put your business into liquidation by way of a high court application. It's necessary to launch a high court application, and that application is quite expensive, between 30 to 50,000 rands to launch that application. So what COBRA will do is instruct attorneys, partner attorneys, Schindler's attorneys will do it, to launch the application to convert the business rescue into a liquidation. But only if you enter COBRA and you give COBRA a chance to rescue your business. Because it would be unfair if you came to the 11th hour and you said, we had other guys try and rescue the business. Cover the liquidation. But even in those circumstances, we'll make an exception. Just come to us and we'll see what we can do. So, and over to you, just around the costs, and then we're pretty much done.
Yes, thanks, Maurice. And so one of the reasons business rescue has had a bad reputation since it started in 2011 is because of costs, and because of the costs that the business rescue practitioners have been taking out of the business. Remember, the business rescue practitioner is effectively in full control of the company when it's in business rescue, and as such, he has mostly unfettered access to the company's bank accounts and the ability to pay himself fees and so on. So the the Companies Act specifically legislates what the business rescue practitioners can charge. Companies are classified as small, medium, and large according to various criteria by the Companies Act, and as such, the business rescue practitioner can charge a certain fee for a small company, a certain fee for a medium company, a certain fee for a large company. The small company charges 1,250 Rand per hour, including VAT, and the large company charge is 2,000 Rand an hour, including VAT, limited to a certain amount per day. Now, those fees are rather outdated. Those fees were legislated in 2008, and it is commonly perceived that those fees, that a reasonable business rescue practitioner fees is well in excess of that. So what most business rescue practitioners who are worth their salt will do is they will propose at the outset that they will put forward what their fees are to the company's management, and they will propose a contingency fee that can be charged as a result of success in the business rescue. Those fees are agreed with management, typically agreed with management, and then put forward in the business rescue plan to be voted on by the creditors. They're typically voted on by the creditors during the voting of the business rescue plan. So you will typically hold what we call a Section 143 meeting at the same time as the Section 151 meeting to vote on the plan. And during that meeting, the fees, contingency fees that he proposed will be put forward, as well as the hourly rates that he proposed as his normal remuneration. It is very important to note that the way we operate and the way that credible business rescue practitioners operate is that their fees will always be affordable to the company, should always be affordable to the company. So the company, in a small to medium-sized business, the business rescue practitioners should always be very conscious of what the company can afford. And when we are dealing with small to medium-sized businesses, we normally agree a fixed fee that the company can afford that is charged every month, in addition to a contingency fee at the end. I hope that answers your question, Maurice.
It does, and that's a wrap. So thanks to the panelists, thanks to the attendees for joining today. We have webinars every day. Tomorrow we have lessons from Kalon Venture Partners for entrepreneurs and corporates to survive and thrive through the coronavirus. That's at 10 o'clock tomorrow, so please join us then. If you have any information, if you want any further information, go to our website. We have a fantastic knowledge base. We also have insights, which give you an idea of what is happening out there. If you go to the Insights tab, you'll see the banks, cases by bank. You'll see how many cases have come into COBRA. 217 companies have really gone through COBRA and the various sectors. So please look out for that. Or just send us an email, info@cobra.org.za. Let's set up a meeting with you and your team, and we'll answer any questions again on a pro bono basis. So thanks. Hopefully I'll see you tomorrow. Thanks all. Bye-bye.